Hi, I'm Martin Grayson, the author of The View from the First Chair, which is about how to litigate, how to think like a lawyer. In this series, I've spoken about various parts of the litigation process. Today, I'd like to talk about settlements. Settlements are an interesting blend of art and science. The science begins at the start, when you must evaluate exactly what your case is worth, or at least as closely as you can. Your evaluation will depend not on liability now. We're talking strictly about damages. Liability will factor into the mix later. Depending on the type of case, let's say a simple contract case, in which the liquidated damages, the losses, are $10 million. No question of that. Setting aside liability as to whether the client you represent as defendant, for example, might be 50% liable or wholly liable, set that aside. We have a $10 million damage case, 100% liability. How do you go about evaluating what that case is worth at settlement? First thing you have to do is calculate a high, a middle, and a low range for settlement. If you assume the judgment value is $10 million, you would want to fix your high range at 70 to 80%. Why that figure? Because if you have to pay 90% to settle the case, it's probably not worth it. You do think you have defenses, you have a leg to stand on, you might as well go to trial and see if you can do better than the 90%. On the other hand, if you're a plaintiff, you would want to accept the 90% every day of the week because that eliminates all of your risk. If the offer, however, is only 20% or 30%, that's a case you want to take to trial because the downside is limited. So plaintiff and defendant each evaluate what for them would be a high settlement range, a mid-range, and a low range. In the case we're talking about now, if you're the defendant and you can settle the case for $650,000 or $700,000, it probably makes sense to do so. That's your high range. If plaintiff will accept that, instead of the potential $10 million you stand to lose, then you should go forward with the settlement at $6 or $7 million. If you're plaintiff, on the other hand, if the offer is $6 or $7 million, you should probably take that as well because you might go to trial and maybe not do that well. You think you can recover $10 million, but maybe a jury will only give you 5 or 6. Here you're at a 60 or 70% range, risk is eliminated, it's a good settlement. You might consider that the middle settlement range, however, or even the low end of your range, depending on how strong your case is. And that's where the two sides have to meet. That's where the art comes in. Because the evaluation will dictate what your offers are going to be, how you're going to move incrementally, and what your final settlement figure is going to be. Let's take the case we're discussing. We have $10 million, not liquidated damages so much as claim damages, perhaps even provable damages. I would want to settle that case in the 60 to 70% range, that is $6 or $7 million, at the outside. I really won't pay more than that because I want a jury to tell me the case is worth the full 9 yards. On the other hand, anything in the middle range, anything below that $6 or $7 million, and certainly into the middle range, which is going to be in the 50% area, is going to be a good settlement for the defense. And anything in the low range is going to be fantastic. The reason we need a low range, however, is because that's where your settlement negotiation is going to be, at least at the outset. The plaintiff, of course, is thinking the opposite. Let's say the opening demand by plaintiff is $10 million. What I want to do, first of all, if the opening demand is $10 million, that tells me I'm dealing with a reasonable plaintiff, because unreasonable plaintiffs are going to demand $30 million, hoping they're going to get to $10 million at the end of the day. Needless to say, in response to a $30 million demand, you offer $1,000. And when opposing counsel says, that is a ridiculous offer, that's insulting, you point out that it's no more insulting than $30 million. And that as soon as he's willing to be reasonable, or she is willing to be reasonable, and discuss likely settlement figures, you'll be happy to increase your offer. Don't be shy, you're not giving anything away by saying you're willing to offer more than $1,000. Part of my strategy in settlement, and part of the strategy I think you should consider, is to be open and frank with your opposition. Let them know what you're doing and why and how you're doing it. So, for example, if you make a $1,000 offer, come right out and say, that's not my final offer. And it's not intended to insult you, but it's intended to show that your demand of $30 million is insulting to me and is unrealistic. So I've made a unrealistic counteroffer. But let's try to be professional and responsible and move forward from here. Give me a counter demand that is reasonable and I'll respond reasonably. So now you showed him that you're being reasonable, you're not going to be obstreperous, you're not just standing on principle, you're really trying to get the case settled. On the other hand, let's say the settlement demand, the opening settlement demand on a $10 million judgment case comes in at $13 million. That's a responsible demand. That's not outrageous. That might very well be the judgment at trial. So you do the opposite of what I just explained with a demand like that. You say to the opposition, that's a reasonable demand. I'm going to respond to you in a reasonable fashion. I'm going to give you a high counter, a high offer, not because I think the case is worth $13 million or $10 million or whatever you might dream it's worth, but because I want to show you I respect the fact that you've done your evaluation, you've given me a figure that is not outrageous, and so I will try to respond by giving you a good figure in return. Normally, if I had gotten, let's say, a $30 million demand, I might offer $2,000 or $3,000, maybe $20,000. But since you've come up with something reasonable, I'll make a reasonable counteroffer. Now you have to figure where the case is going to go. Your reasonable counteroffer can be $25,000, or it can be $250,000. That reading depends on what you think of the opposition, what he really wants from the case. Did his opening $13 million demand mean that he thinks the case is worth in the $6 or $7 million range? Or did it mean he thinks it's worth $10 million, but he wants to get the ball rolling as quickly as possible? If it's the second, the latter, you're going to offer the $250,000 because he wants a responsible counter. On the other hand, if you think he's still fishing, maybe he's inexperienced, or maybe in your conversation you've learned that his evaluation is not what it should be, and you think his final figure is in the $6 or $7 million range. In that case, you don't want to offer him the $250,000, because now he's automatically splitting the difference between $250,000 and $13 million, which comes down to around $6 or $7 million, which is what he thinks the case is worth at judgment. Knowing what he thinks the case is worth at judgment, you've got to lowball that. So you make him a $25,000 offer. When he says, oh, that's ridiculously low, you say, no, it's not. It's a responsible offer. This case may be worth $3 or $4 million at the end of the day. Of course, you're negotiating here. You're not telling him exactly what you think. You're telling him what your negotiation position is going to be. Case may be worth $3 or $4 million at the end of the day, but I've got to signal that we're going to meet somewhere in the middle here between the $25,000 and the $13 million, which you've demanded, which may be a little over the top. So give me a good second offer, and I will raise my offer to you significantly. This is important because it's not the opening demand, it is the second demand or the second offer in any case that tells you where it's going to wind up. He's demanded $13 million, you've offered $25,000. If he comes back with $9 million or $10 million, then the case is going to settle in the 5 or 6 range. Tops, depending on if you can scare him a little more. If he comes back with $11 million, though, he's signaling to you that he still thinks the case is worth $6 or $7 million, and you may have to go into your middle range to settle the case, not your low range. Let's say he comes back with a $9 million offer. He's already signaled to you that this case has a lower judgment value to him than you think it has. So you're going to be settling in your mid to low range, not your high range. He's come back with $9 million, which is a $4 million or approximately 25–30% drop from his opening demand. Again, a significant drop. When you go back to him, you're at $25,000. If you go back with $50,000, now he's going to get upset. He's been trying to be responsible, and you've been nickel and diming. So I would say now is when you go back with a significant offer, maybe $200,000. That gets his attention. You're already into 6 figures, and you can signal the $9 million was reasonable. I really think you want to settle this case now as opposed to taking it to trial. I'm never going to come anywhere near the $9 million because my client won't let me, which is always the good boogeyman that you've got in the closet. But we can negotiate here. I'll give you a reasonable 6-figure offer, and then we'll go from there. Then you give him the 200, maybe even 250,000. See where he goes, start playing the game. If he gets down to the $6 or $7 million range, which is your mid-range for settlement, and below what you consider judgment value, then you just play the game as long as you can. If he comes back with $7 million, let's say, and you're at 250,000, you go to $1 million, because $1 million is an impressive number, but at the same time, you split the difference between $1 million and $7 million, and you're way into your middle to low range. You become a hero to your client, you settle the case at a good figure. Knowing what the opposition is doing and having your evaluation in place before this dance begins will give you the best possible outcome.